Well, for me, of course, I think the most important work possibly anybody could do is estate planning. And my goal, I guess, is every year to learn more about it and do more for people, help them understand what they can accomplish through their planning for themselves and for their family. And not everybody's going to really worry about that or even think about it. But for maybe the majority, if not everyone in this room, people recognize that you can accomplish a lot, yes, for the kids, yes, for the grandkids, but also for yourselves if you'll focus on your planning now and focus on the main issues rather than getting all hung up on minimizing taxes or some of the issues that we normally think about. By taking the time, hopefully having good discussions, focus on really what we can accomplish. And you know, people say, I'm not going to be here, I'm not going to worry about what happens when I'm gone. But really the people who I think ought to do estate planning, they've spent their whole lives working for themselves and for their family. Why wouldn't they want their family to succeed after they're gone? They've worked day and night to put together an estate. Why wouldn't they want that to benefit their family rather than have it frittered away for whatever reason? If we're going to do estate planning, we're going to be focusing on what we have, who we'd like to benefit from our legacy, and what we can do to help them benefit from it. I talk about creditors and predators. Creditor being someone who maybe gets a judgment against you, or someone with whom you've done a contract. A predator, I put that category, ex-spouses, ex-daughters-in-law, ex-sons-in-law, people who also think they have a claim to part of your family money. Estate planning can help the family to protect what you put together from creditors and predators. Probably all of you, or most of you, have heard the definition that we follow in our office with regard to estate planning. We say, I want to control my property while I'm alive and well able to do so. Then if I become disabled, I still want to control my property for myself and my family. And then when the time comes, I want to pass my property to whom I want, the way I want, when I want. And I want to save every last professional fee, court cost, and tax that I can. Well, there's a lot crammed into that. But it starts with control. As we get older, we lose control. Our health starts presenting issues. And we find ourselves at the mercy of the medical establishment doing things that we never thought we would have to do. We lose control of maybe our finances. Our earnings are affected by maybe our retirement or different aspects of the economy. And the level of complexity and change in society every year gets worse. And I don't care who you are, keeping up it's a major challenge. So if we can help you maintain control now, that is really important. And as I've thought about this, I'm thinking, yes, we want to maintain control over our healthcare decisions. We want to maintain control over our finances. But really what we want when day is done, we really want to be able to live our lives with dignity. And it's not that easy the older you get. I think of my father-in-law, who was my law partner that some of you here know very well. He was a class act. Wouldn't you say that, Stan?
I would say that.
And he died a couple years ago at age 92. His health presented a lot of issues to him. At each stage, he addressed the situation in a mature way, and he was on the front end of it. They had a beautiful house. He didn't want to leave that house, but he recognized it made sense. So rather than being shoved out at some later point, he agreed to move into a condo. All right. As health issues confronted him, he dealt with them. And it's not so easy to maintain your dignity when some of these things happen, but he was able to do that. And he handled his health care and his finances in the same way. He thought about them, he took action up front, and was able to live his whole life with dignity, including at the very end. Pretty good goal. And I think that's an area where estate planning can really help us. And of course, yes, we want to pass our property on to our kids. We want to pass on our legacy. Most of the people that we deal with are not candidates for a related area of planning called long-term care planning. But it's an area that I think there's a lot of confusion. Everyone who's come to our office has filled out an organizer listing their concerns, and one of those concerns relates to losing family money to nursing home expenses, to long-term care expenses. We've got clients with very large estates, and they check the highest level of concern, just like people with very modest estates. The planning that most people in this room have done based on living trust does not directly address that. Since a living trust is revocable and changeable, the way I describe it is we've taken our assets from one pocket and put it into the other. We still control it. If we have a trust and we want to terminate it tomorrow, we can. We want to take property out of the trust tomorrow and put it back in the next day, we can. Since it's revocable, it has no effect in terms of liability for long-term care expenses. Or if a family wants to apply for assistance, such as Medicaid or Veterans Aid and Attendance benefits, the fact that we have a living trust doesn't hurt anything, but it doesn't help because the assets are still deemed to belong to us just as they did before the revocable living trust. So for some people, we're doing long-term care planning, and that involves irrevocable transfers. Maybe to a trust, maybe to family members, but it's not the kind of planning that we've done here. Maybe that's the kind of planning that your neighbor ought to know about, or a family member. Maybe you want to know more about it, and maybe it's appropriate for part of your planning also. But the planning that you have in place right now, I think for everybody in this room who's worked with us, is only estate planning. It's not long-term care planning. So you're here, most of you, as members of our Peace of Mind Protector program. And the reason we have that program is that ever since we started doing estate planning, we sit down with people and we say, you know, we're going to take all the time it takes to really figure out what we want to accomplish with your planning, and then we're going to put that plan in place. And it will, if I may say so, it'll be a good plan. But we just know we're going to have to change it. Family's going to change, your health's going to change, we know the tax laws are going to change. And so I'm telling clients, you know, we ought to get together every 2, 3, 4, maybe 5 years. Do you agree? Everybody nods their head. And then when we invite people to come back in, it doesn't happen. It happens for some people, but for a lot of people it doesn't happen. People, I think in the back of their mind, oh, we already handled that. That's done. Don't need to worry about that. And that might work for their family, possibly, but I don't like the odds. If the clients haven't looked at their planning at least and tweaked it as time has gone on, it's probably not going to do the best job possible for them and their family. So that's the basis for our program, keeping our plan updated. Also, just like this workshop, learning more about estate planning. We're focusing more on the basics today, but some of you have been to our other workshops where we've dealt with related issues that might apply to you, that you might want to incorporate into your planning. Again, I think we've got pretty good plans in place for the people for whom we've worked, but you may have noticed those binders are pretty thick, and we did not discuss every paragraph We don't need to necessarily discuss every paragraph, but there's a lot of planning in there that if we addressed, you might say, well, Keith, that's not bad, but I think I'd rather do option B. Well, okay. This program allows us to talk more about options A and B in different areas of the planning and customize your plan more and more for you so that the plan fits with the life, the control you want to maintain now and the legacy you want to pass on to your family. Okay, so people who come into our office will sit down and we'll try to understand what they're wanting to accomplish, a little bit about their estate. And for some of them, I'm going to suggest, you know, a plan based on wills is probably best for you. And here are the reasons that I think. For people who have larger estates, who have more complex situations, no surprise to you, I'm going to suggest they want to really look at a living trust-based plan. And I'd like to spend just a couple of minutes kind of taking a step back and saying why I'm suggesting that, why I've suggested that to you, and at least from my standpoint, how you might approach why you have a living trust-based plan. And of course, you don't have to have one. There's lots of options for estate planning. One of them is you don't do anything. And if you don't do any estate planning, don't worry, the state of Montana has done it for you. It's called the law of intestacy, the law of people without estate planning. And it's got a scheme that really makes a lot of sense. If a husband dies in a second marriage, leaving a spouse and kids, they're going to inherit. If a husband dies in a second wife, a second marriage, they'll inherit, and so will the kids from the first marriage. And if there's no wife and kids, the parents will inherit. If there's no parents, the brother. It's a scheme that makes some sense. There's no protective arrangements whatsoever. There's no consideration of whether one of the kids or grandkids is receiving government benefits so that every dollar we give them, they lose a dollar. There's no consideration of whether one of the kids has a drinking problem and any dollar we give him is going over to First Avenue South. But it can work. For people with very modest estates, maybe it's the best planning. I have a hard time saying that. Owning property jointly. Joint tenancy with right of survivorship property. I don't care if you got 14 wills and trusts. If you have your house in joint tenancy with husband and wife dies, we take an affidavit over to the clerk and recorder. It says, my husband and I owned this property. He's died. I'm entitled to ownership of this property. Signed wife. It's done. Between spouses in a simple circumstance, that can work fine. If there's tax issues involved, it doesn't work so fine. But for people with a modest estate who don't have tax issues, might work fine. Between spouses, I really am not too excited about having a joint tenancy relationship with a child, however, because then that child has an ownership interest in that house. And if the child goes through a divorce or the child has creditor problems of his own, all of a sudden the family house, mom's and dad's house, is subject to the claims of creditors for the son. And if we've got 3 kids and mom put the house in joint tenancy with the oldest, being sure that he would share it with his siblings, but his wife, when mom dies, tells him, you don't need to share it with your siblings. That's not how it's set up. That's ours. Maybe that wasn't the best planning. Joint tenancy can work. Designate a beneficiary. If we have an IRA, if we have life insurance, if we have a 401k, the beneficiary designation will say what happens to those proceeds. We name a primary beneficiary, we name a backup or a contingent beneficiary. That will work to transfer those assets. And we have bank accounts can be subject to what's called a POD, payable on death provision, where if that's set up properly, whatever's in that bank account automatically goes to whoever you've named. If it's a securities account, like downstairs at Davidson, it's the same thing, except it's called a TOD, transfer on death. It'll go to whoever you've named. We even have that in recent years for land, what's called a beneficiary deed. You keep the property in your name, but you record a deed that says, if I still own this property when I die, give it to my son. That works. That'll avoid probate as to that asset. That planning, again, for people with very modest estates who don't have issues, they don't have tax issues, they don't have issues with regard to kids or grandkids who have problems that would not allow them to take advantage of the property. They don't have families where family dispute seems very likely, might work fine. For people with more complex estates, to me it's substandard. We could base our planning on wills. Wills work. Of course, the will has to be probated, which means it's filed with the court, and the proceeding to settle the estate is subject to the world's knowledge, I guess, and subject to the supervision of a judge. Generally, probate works just fine. It's a little bit more public. If there is going to be a family dispute, we've got to give notice to everybody and lay out all the specifics to give them a chance to complain. So if we see a family dispute coming, maybe a will isn't the best planning, but for a lot of people it can work fine. I am not a big advocate of will-based planning for people with larger estates because, number one, if we can avoid a probate, if we can ever avoid going to the courthouse, that's always good, whatever reason. And I say that as a former trial lawyer. And if we see family disputes, I really like the idea of arrangement where someone passes away and we handle his or her affairs just at a desk like this, just sitting across, handling it, do our work, we're done. I like that way better than going to the courthouse, filing everything for the public, and then sharing everything with everybody to give them a second chance to second guess what we're doing. I've got a probate right now where our client was a very nice, very businesslike lady, but in later years she started slipping, and whereas she'd come in before and made changes in a very formal way, she signed the documents, dated them, she took to getting out her paperwork and scratching things out, putting in other information, and then initialing it. Well, we think we know what she meant. We don't know when she did that. We really question her capability at that time. Well, she did that through will-based planning. So all the heirs who are affected by these changes, we've got to give notice to them of what all happened, what we think the results are going to be, and we'll have a hearing. If we'd had a trust, we wouldn't have a hearing. We would go out and we would do what we think is right, and if they want to object later, okay. But we haven't exacerbated the problem as we have had to in this situation. I contrast that with a trust administration I'm doing up in the Flathead right now. A person died, his estate was probably 3 times bigger than this lady's. We had a trust that we'd done for them, and there's a great accountant I work with up there. The accountant handled about 95% of the trust administration. I met with the lady 3 times, and it took a number of months because they had a lot of assets. Not one hiccup. And one of her sons is a total ne'er-do-well. But no problem from him. He's getting part of the estate in a protected way, if I may say so, but we sailed right through the whole process. So a will might be fine, but I like the odds of using a trust to accomplish what we're trying to accomplish in an efficient way, minimizing disputes, and just generally letting the people whom we trust handle things. So you probably noticed in our meetings they ended up being a lot more in length, covering a lot more questions than you ever expected when you first came to our office. And some people, I guess some people have complained about that, other people have said this has been great, but it surprised them. And that's because with the trust-based planning, you guys are making a lot of decisions up front that otherwise would be made later on by maybe you, or maybe the family, or maybe a judge. But I was talking to a CPA the other day, and he said it's like a pre-probate. while you guys are here, while you're sharp, we're figuring out all your assets, we're putting it all down on a list, we're coming up with values, at least guiding values, and we're capturing your idea about what ought to happen. Well, I've got a gun collection, and I've worked a lot with Sam Smith out in Lewistown. We ought to contact him. He'll help us sell it, or whatever. That's really valuable to people we leave behind. But with a trust-based plan, once we got that trust and plan, we sat down and we talked about the assets, and we got things organized so that if something happens to us, we've made our job way easier for the family. And that's worth something. With a trust-based plan, it's in place, but you're maintaining control. Yes, it's there, but it's not affecting your control. If you become disabled, the odds of our ever going to the courthouse to get a guardianship are very small. And that's because you've already planned what will happen, and you've taken off the table the issue of money. When money's on the table, that's when other people really get interested in getting involved in your affairs. You've taken that off the table and decided, here's how we'll decide if my level of capability is such that I need help. Here's who will make that call. And if she can't, here's the backup. And then if that call is made, here's who handle my affairs. Yes, I got 3 kids. Yes, one of them is here, one of them's in Washington, one's a CPA, one's an artist. They all have great capabilities. But I've decided who will handle my affairs if they can, so we don't have to argue about who's most capable. Again, that's worth something. And then, of course, estate planning is eventually going to deal with someone passing away. You've decided as many of the issues as have made sense up front so that your wishes are followed. One of the confusing things about this planning that we do is we're using trust, and if you sat down with me, you've probably heard me use the word trust 25 times in one meeting. And sometimes I mean this, and sometimes I mean that. So that's why, I don't know, 5 years ago, we started using diagrams. We started getting up on the board and using our whiteboard. We started preparing diagrams. Some of you for whom we did planning way back when, they weren't using diagrams. If we update your planning now, we will. But we are clarifying, we've got a living trust that's in place now, and it owns most of our assets. And on page 24 of that trust, it says, when I pass away, what goes to my daughter Sue will be in a trust for her. My trust is revocable. I do whatever I want to. That trust for her, once I pass away, I want you to put that in trust for her. That's an irrevocable trust. And here are the terms of her trust, nothing to do with what's going on now with regard to my revocable living trust. Well, so what is a trust? It's an agreement, usually in writing, with respect to property, where one person agrees to hold the property and manage it for the benefit of another. So I say we've got 3 hats. We've got somebody with property. I call it trust maker. That's Randy. Randy's the trust maker. He's going to do a trust. And he says, I'm going to set this up, but while I'm here, I'll manage it. I'll be the trustee. And while I'm here, it's for me and my wife. I'll be the beneficiary. So I'm wearing all 3 hats. So a trust is an arrangement that Randy puts in place. Initially, he and if his wife's the co-trustee, they're the only ones who sign it. They're the only ones involved. But as trust maker, he's saying, I'm putting this property under the control of you, Mr. Trustee. I just happen to be the trust maker and the trustee for right now. And here's what I want to have happen unless I change my mind. So people will say, well, okay, we get this trust signed up. Do we have to record it somewhere? No. When somebody passes away, do we have to record it somewhere? No. Somebody becomes disabled? No. It's a private document that we follow. Now, if there ever was a lawsuit, then yes, we're going to have to present that document and let the judge decide whether what we're doing makes sense or not. But Hopefully that's not going to happen. And when we sit, so when someone passes away and we're going to distribute assets, just like I was describing up in Kalispell with the business owner who passed away, we'll sit down and we'll look at that trust and we'll say, okay, these assets go over here, let's sign that deed and that bill of sale. These go over here, let's sign that deed and that bill of sale. Of course, we're going to look and see whether there's any estate tax owed. If there's a return required, we'll fill that out. We're going to make sure income taxes are paid, those kind of things. But we're going to do all this in the CPA's office, for instance. We don't have to give notice to anybody, we just do our job. Every day I have a meeting with somebody and we're talking about their estate planning goals, and sometimes they'll say in their questionnaire, I'm a little concerned about my kids getting along. Or my neighbors just went through a horrible mess where there was a family fight. I don't want that. We'll hear that. But most of the time, we'll talk about their concern. I'll say, well, are you at all concerned about a family dispute? Oh, no, that'll never happen in our family. Kids get along great. And I always say, I'm sure that's true, but would you mind if we spend a little time just talking about what might happen? And usually I'll get people to admit, probably won't happen, but it wouldn't be a bad idea to plan just in case it did happen. And of course the fact is it does happen. It happens every day. Kids don't get along. I had a meeting 2 weeks ago when I was up in the Flathead with some people from Bigford. The lady was pulling her hair out. She said, my grandpa died a year and a half ago, and my dad died about 9 months ago. My grandpa died at 102 or 103. At age 98, he got remarried to a lady 26 years younger. Well, she died before him. But the first thing she done after they got married was take him to the lawyer's office and have him do a new, I don't know whether it was a will or a trust, giving everything to her. And it said, if she's gone, it goes to her kid, not to the grandkids. Okay, so now my lady up in Bigford, she says, this kid won't return my phone calls to make arrangements for us to go over there to Washington to get grandpa's mementos, the photographs and stuff. He won't return the phone calls, much less the whole issue about his getting the estate. And she said, and then my dad died, and he had a trust. And the trust said, I and my brother, we're the trustees while we're alive, and for our benefit. And then when one of us passes away, the other brother's the trustee for the benefit of the surviving brother and kids. Sounds pretty reasonable, except that uncle has never gotten along with this lady and her siblings. There's been a family fight forever involving that uncle. Now he's the trustee in charge of their inheritance from their dad. So probably never going to happen in your family, but if we can deal with family disputes in our planning, that's really a good thing. If we have will-based planning and somebody becomes disabled, we've dealt with it, but we've dealt with it through a power of attorney. And a power of attorney might work just fine, but all too often it doesn't work, and then we end up going and getting a guardianship set up. And that may work just fine too, but we need to account to the court, we need to run everything by everybody else. There's a little thing called attorney's fees to get it set up and to maintain it. Better if we don't do that. The living trust, we're probably never going to have to worry about that because the living trust deals with disability. Okay, well, for assets not in your trust, you want a way to deal with them, to manage them if you're still here, but you can't manage them. You've got in a car wreck, or you've got an illness. And we do have a financial power of attorney in your binder. It only deals with assets not in the trust, because the trust deals with those people you've named as trustees. So in most cases, a high percentage, if not all your assets, are under the control of the trust. So we don't really care about this. But you set up a trust and you get Alzheimer's and you live for many years. 2 or 3 years down the road, we find out that you forgot that when you had that property up at Lincoln, you not only had the original property, but you bought that property across the river. Remember that, 10 acres? Oh, yeah. Well, that's not in the name of your trust. Well, at that point, if your Alzheimer's has gotten to the point where you're not signing any deeds, the person you named in your power of attorney, on page 13 of that power of attorney, it says, my agent can transfer my property into my living trust. Not bad. It's a problem if you haven't authorized that. So part of our planning, we say, no decision making involved, but I want my daughter to be able to know what's going on with me if I'm up at the hospital and she comes in from wherever. Well, if we have a trust, as I said, right now you're wearing probably all 3 hats. You set it up, you're managing it as the trustee, and it's for your benefit. It's a little confusing because at one point you're thinking of it as a trustee, the person who writes the checks, and at another point you're the trust maker, the one who reserves the right to change the trust. Well, focusing on a trust maker, what are your rights? You're the one who, among other things, picks the trustees. Yes, you're the trustee up front. If you're married, usually you've named your spouse as a co-trustee, and you've said either of us can act alone. And then you've said if we can't serve one of us, here's our backup. Maybe if husband can't serve and wife's able to, she serves alone. Or maybe if husband can't serve and wife can, wife serves with someone else. But we have those arrangements set up. You've selected those, and usually we spend some time talking about that because to me that's one of the most important issues to talk about. It's one of the most difficult to deal with. And I want to suggest to you, almost all of who already have trust, it's worth going back and thinking about that. Because everyone's default answer is, first I'll name my spouse, then I'll name my kids in birth order. And sometimes I'll name them jointly, but sometimes they'll be individually, and that's it. And I'll go along with that. You don't see me arm wrestling you on that or anything. But that's really worth considering, because as soon as you name the oldest as trustee, and that person starts fulfilling their duties, the other kids are wondering whether she's really doing her job. Is she really honest? Is she really doing the best thing she could do? All these issues. And again, never going to happen in your family, but in a lot of families, when we name one child as a fiduciary, as a trustee, or if you had a will-based plan to be the personal representative, it creates antagonism among family members. Now, I'll bet if I queried this room, about half of you could come up with a story where that's happened. So just naming a family member creates the possibility of division among family members. Plus, how much time and capability does that child have? If they're out in St. Louis, it's not that easy to deal with a lot of physical assets in Great Falls. Now, the trustee can hire somebody to do things, and that's great, but anybody who's hired usually could use a little supervision. And it's kind of hard to supervise from St. Louis. Plus, in a way, I think a child is going to, when they see they're named as a backup trustee, they're going to feel like mom really trusts them. It's an honor, but it's also a job. Particularly if you have larger estates like a lot of you do, it's a real job, and you can make mistakes. For instance, in the planning that most of you have, it says when the first spouse passes away, the second spouse can just follow through and do what the plan says, or that surviving spouse has the right to tweak what happens. It's called a use of a disclaimer. where the surviving spouse says, yes, my wife left me her whole trust estate in what Keith calls a bypass trust, but I don't need all that. Or the trust is set up so that my wife's estate comes over into a marital trust, because we didn't think there was going to be an estate tax issue, but it turns out there is. And if I toggle that switch with a disclaimer, I can have still the same money for my benefit, but it'll be taxed to minimize estate tax. That's in your planning. And we probably didn't talk about it, or if we did, we just zipped through it. Well, if we have a disclaimer, probably don't need to use it, but if we do, it has to be toggled within 9 months of the date of someone passing away, which that's not so hard, but the bigger issue is you've got to toggle that switch before you take advantage of the property. So for instance, wife dies and she leaves a securities account to husband, and husband the next month goes down to Davidson and has him switch the account and start paying the dividends into his account. We're not disclaiming that asset anymore. He's taking advantage of it. Well, okay, probably doesn't apply in most circumstances, but it's an example of where the person who all of a sudden is serving as trustee has a complexity to deal with, and they can't just blow it off. They need to address the circumstances in a timely manner and at least look at an issue and move on to the next one. Of course, trust estates, just like any other entity or person in the United States, needs to pay tax returns. And it's a different tax return, it's a different time schedule, and there's an election to be made there to have a trust treated the same way as a probate estate. Probably want to toggle that switch. So my point is, when we pick trustees, probably most of you have picked your kids when spouses can't serve, and maybe you'll stick with that, but it's really worth thinking about that and wondering whether some of it should be changed. Also, as trust maker, you've got the right to adjust the powers the trustee has. The way your trusts are drafted as a starting point, the powers are drafted as broad as can be. My theory is we pick good people and we give them the discretion to do their business. Maybe we want to limit the power in certain areas. For instance, I've got somebody coming in this afternoon. They have a family farm, and they want their trustees to be able to deal with the property, but they don't want them to sell it for a period of time. So in their trust on page 14, where it has a power to sell, we're going to add a provision to that. May not apply to you, but it's worth thinking about, because when we did your planning, we had so many issues to talk about. Maybe we didn't talk about a specific asset or a specific idea that you would now like to see followed in your estate. And of course, successors. Hopefully we've named successors that make sense. I'm usually saying, when we're talking about trustees, let's focus on who could serve really well now and into the near future. Let's not worry about whether they could serve 20 years from now. So if we're naming somebody the ripe old age of 60 or something, hopefully they got a lot of years. Well, maybe it's been 10 years since you did your planning, and that person now, their health isn't so good. Maybe we need to be looking at different successors. As trust maker, you reserve the right at any time to change who you've named as trustees. And a little side note there, I've drafted, I think, every trust for a couple in the last many years to say the surviving spouse has the right to change trustees if he or she wants to do that. In other words, I have enough confidence in my spouse that even though we named a certain person as trustee, if that's not working out, they can bump that person. I think that's good planning. Maybe we need to tweak that in your case. Of course, as trust maker, you reserve the right to say who's going to benefit from your estate. And you're going to leave something to your spouse, I know that. How are you going to leave it to your spouse? I'm going to come to that in a few minutes. You're going to leave something normally to your family. Some of you have left things to charities. And I'm feeling I'm not really doing my job in our discussions to bring up that topic. Because a lot of you have very substantial estates, and probably if you spend some time thinking about it, there have been organizations, there have been people in your life in the past who've really helped you, who've been important to you, and it might mean a lot to them if you remember them. Doesn't mean you're going to give them half your estate. But I think I could do a better job helping my clients just take a step back and think about that, to remember people. You might want to remember them. Okay, so you're going to leave something to your surviving spouse. How are you going to do that? Most of you, I think, have been at workshops I've given over the last couple of years, at least one time, where I've addressed this issue. But it's a huge issue. Here's a diagram of my plan. It probably looks a lot like a lot of the plans that couples have now, where I say, setting up this living trust, when I pass away, I may leave a tangible personal property memorandum to say who gets my shotgun and the pistol that I got from my father-in-law and china that I got from my grandma Hannah. Everything else is going to go down, according to Article 7, based on how big my estate is and what the federal estate tax exemption is. And it's set up to say, whatever I have, if it's less than the federal estate tax exemption, goes into a bypass trust for Becky, for my wife. She's the trustee. She gets all the income. If she needs part of the principal, fine. But then when she's gone, you don't see it here, but it goes down to Hannah. Well, that's a great tool for minimizing estate tax, because I call it a bypass trust, because when I give it to Becky, no estate tax, and it goes from Becky to Hannah, no estate tax. Becky gets to benefit, but it bypasses her estate for estate tax purposes. Great for estate tax. Except right now the exemption is $5,430,000. And even though I work really hard, I still haven't gotten up to that number quite yet. Well, so estate taxes right now is not an issue. I don't trust Congress to leave it at that very generous number, so I want to have backup planning to deal with it. But I might want to think, do I want to have my estate for Becky go in this bypass trust? What I'm saying is it's not needed for tax purposes. So one alternative would just leave it outright to Becky. Then she can put it in her own living trust and do whatever she wants to. I'm not a big advocate of that, because when I don't want to say Becky's an artist. I don't want to even get into that. But Becky has to manage it, and I'm sure she'll do great. But that property, if I leave it to her outright, is not protected. So Becky gets in a car wreck, and my buddy Xander Blewett gets a big judgment against her, more than our insurance. What I left to Becky is, or that's one to Xander. Or if Becky wants to get remarried, which I want her to, if that makes sense to her, whatever I left to her outright, that's going wherever she and the new husband and the new husband's kids say it's going to go. Well, by leaving it in this bypass trust, it's protected. So she gets in a car wreck, yes, she's able to benefit from that property, but it doesn't belong to her. So Xander's going to have to kind of cut back his claim a little bit. And the bypass trust has a remarriage provision, and it says if Becky wants to get remarried, great, but she needs to get a premarital agreement with this new guy, or he waives a claim to the Tokriut estate, or she's going to lose out on the bypass trust. So it's given Becky some oomph to ask for a premarital agreement. Well, if I left it to her outright, we don't have that provision. The downside of this bypass trust is it's great for estate tax, and it really has no immediate other tax consequence. But down the road, it might have a tax consequence to Hannah, my daughter. And the way that works is, I leave something to Becky. I get hit by the bus tomorrow. I leave something to Becky. It gets valued, goes into this bypass trust. Let's say she doesn't spend it, goes down to Hannah, and it's 10 shares of IBM. And Hannah inherits it from her mom. Her mom lives another 30 years. When I gave it to her, when I passed away, it was worth, I don't know what IBM, $10 a share. When Becky dies, it's worth $100 a share. And Hannah said, I'm going to sell that. She sells it for $100 a share. If it came down through the bypass trust, she's going to have to pay capital gains tax based on the $100 a share she sold it for, minus the $10 a share it was worth when I died. So she's got $90 of gain for each share. Well, if we didn't do it that way, if we had what I left to Becky be treated as part of Becky's estate, if there's no estate tax, we don't care about that, but then when Becky passes away, she still has those shares get valued in her estate. 10 when I died, 100 when she dies. Hannah sells it the next day. Hannah gets to figure her capital gains based on what it was worth when Mom died. So she sells for 100. Her basis is 100. No gain, no capital gains tax. So if we have assets that are going to appreciate, and if the spouse, the second spouse, lives a long time, so there's lots of appreciation, the daughter is going to really wish that Mom and Dad had set up their planning so that the assets that went from Dad to Mom were, we say, stepped up in basis, that were in Mom's estate when she died. That's the tax angle. 2 points. First of all, you might say, Keith, we have this $5 million exemption. Yes, we know Obama's talking about lowering it, but he's got no chance of doing that. And we're not worried about Hillary and so on. We don't think we're ever going to have an estate tax issue. So let's forget about that bypass trust and either leave it outright or leave it to Becky in a trust where it's included in her estate. Won't trigger any estate tax, and we'll get that step up. That's an option. If we don't do that, my second point is, in this bypass trust already is a toggle switch. And the toggle switch says, if Becky, she's lived 18 years since poor old Keith died, and she's got a lot of appreciated assets, and neither Obama nor Hillary nor Chelsea could do anything to get the estate tax exemption down, so there's no estate tax issue. Becky can arrange to have the toggle switch switched and have what went to her taxed as if it belonged to her, as if it had gone through another way than the bypass trust. Okay, that's really neat planning. It's in your planning. Who's going to remember that? Who's going to get on that and see whether we toggle that switch? Well, if you're members of the Peace of Mind Protector, I'm going to be telling you every year to be remembering that. That might help. You might say, we're going to stay on top of our plan. If that happens, we'll toggle that switch. Or you might say, Keith, we're not so sure. We're in the program now, but we're moving to Florida next year or whatever. Maybe we'd want to change how you leave the property to the surviving spouse. It's worth talking about. Now, I kind of blew through this, so if I lost you on this, the main point is the planning you have right now can work, even given the estate tax right now. If we use that toggle switch, even if we have a lot of appreciation, we can still get the result we want. But we might want to change our planning depending on what we think about it. Okay, well, what about, okay, we talked about Becky being a car driver, but I can't resist, some of you have seen this picture already. I just love this picture. This is talking about why Becky wants to leave her property to me in trust. Because Elaine wants Becky's share. We've already talked about that. But what about the kids? How am I going to leave my property to Hannah? I could leave it outright, or I could leave it in a protected way in a trust arrangement. We just got done talking about how when we leave it to a spouse, there's a tax angle. There's really no tax angle per se, at least directly involved, when we leave it to our kids. It's a matter of whether we want protection or not. So, what if your kid hits the skids, he hits the school bus, gets hit by the school bus, hits the bottle, hits the lottery? And what if Hannah gets married to Fred? If we've left, well, by the way, I've done this. Probably a lot of you know this. I did. I'm not saying Hannah gets her inheritance from mom and me outright. She's a great kid. Many of you know her. She's way more frugal, smarter than I ever was at that age. But her inheritance in our living trust says, when Becky and I are gone, for the first 10 years, I want somebody to help her manage it. She's got a great aunt up in Columbia Falls. She'll be the trustee to help Hannah. After that, I think Hannah will be able to manage things just fine. But I don't want Fred to get anything. And I'm proud to say she passed the bar last year. If she gets sued for legal malpractice, I don't want somebody getting into her pocket for that. So after 10 years for Hannah, her property stays in trust, but it's what I call a beneficiary controlled trust. So here's Hannah back her freshman year in college. She's the beneficiary of the trust. She controls it. So she gets those 10 shares of IBM. She wants to sell them. No problem. She wants to give the proceeds to her favorite charity. She can do that. But the inheritance from mom and dad is in a trust, and it's set up so that if she does go through a divorce, that Fred, he's not going to automatically be getting half of it. A lot of you have beneficiary control trusts in your planning already. The last 3 or 4 years, I make a real point of trying to get people to get their mind around that. I had a family meeting yesterday where the daughter came, we were trying to get trust signed, and I said, I'm really glad you're here because I can explain to you what your parents are doing. You don't have to keep it in this beneficiary control trust. If you want to get rid of this the day after you inherit it, fine. Don't ever do that though. She says, I totally get this. And I'm talking to my brother. He's not here. I'll explain it to him because he's going to hear it the same way. So people get this. There's a real benefit in today's age to avoiding creditors and predators. Well, that's just a little description of the beneficiary control trust. It's for the child. Child and the grandkids usually are the beneficiaries. It's got protection. And again, child can terminate the trust. As I said, I don't think I've really done a good job with regard to suggesting people think about charities. I've already talked about that. If a person wants to give to a charity, there's lots of ways it can be done. Okay, so we have a great living trust, been in place for many years. Finally, you meet your maker. What's going to happen? Well, it depends on whether we stayed on top of our planning or not. It depends on whether your assets, when you pass away, are subject to the trust or they're not. If they're not subject to the trust, we'll hope there's a beneficiary designation. Or we'll hope it was held in joint tenancy with someone who's still alive. Because if not, we're talking about a probate. And not the end of the world, but geez, we spent all this time with all this planning to avoid a probate. Now we have to do one. Our minimum charge right now to do probates is $3,000. That's the minimum, and it's going to go up from there. So we want our trust to be properly funded. And that means sitting down when we first do our planning, as most of you have done, making sure we're thinking of all the assets and coming up with a plan on how they ought to be held. And then it means as time goes on, going back and looking and seeing what's happened. Well, we sold our house and we bought a condo. Okay, how is that titled? Do we remember we have a trust and maybe put that condo in the name of the trust? Not the lady who was in Tuesday. Okay, well, we can deal with that. Well, now we're going to do a deed of our condo to our living trust, but she's a pretty business-like lady. They've had living trusts since way before I was involved. They dropped the ball. They forgot they had a living trust and had assets that were in a trust sold and the replacement asset not in the trust. So part of your job, if you have a living trust, is you need, when you make transactions, to at least think, I've got a living trust, I wonder whether that ought to come into play here. And we don't charge for phone calls, I hope you all know that. You can always call our office. If you're in the Peace of Mind Protector program, we're going to be talking about it in any case. But if the trust is properly funded, it's going to be way easier to handle your estate. So that can mean the condo is owned by the trust. Or it can mean we had a bank account over at US Bank, and when we first did our trust, we had Social Security payments coming in there, we had payments going out. It was such a hassle to get that arranged, we didn't want to change it. So we said, we'll leave the ownership in your name, but we'll have a POD, a payable on death provision, to your living trust. That works. That POD provision will send that money right to your trust. We don't need to worry about a probate. And if it's an account at Davidson, securities account, we got a TOD, belongs to Joe, payable on Joe's death to Joe's trust, works fine. If the individual owns the asset in his or her sole name, and it's not real estate, if the value of all that property outside of the trust is less than $50,000, we can pass it by an affidavit. So I had another trust administration in the Flathead where we thought we had all the assets taken care of. Husband passed away, and we found out, well, he owned a life insurance policy on his son, and it was worth about $11,000 cash value. And he owned stock in a corporation that he'd just forgotten about. It was worth about $15,000. So we got $26,000 of assets. Since it's less than 50, all we had to do was we prepared an affidavit, we sent it to New York Life, and we sent it to the company that's the transfer agent for the stock, got them transferred. That was great. We just lucked out. If it was real estate, I don't care if it's a quarter of an acre, if it's in the name of Joe Blow, Joe Blow is going to have a probate. Probate. If you met with me, you haven't found me jumping on the table talking about how bad probate is, because in Montana, it's not nearly as bad as it is in many states. And I don't even know the worst states. I've heard California is not a very good one, and a lot of the East Coast states that have laws from way before Montana's formation. In Montana, it's not so bad. If there's no problems and we can sail through it, it's required a minimum of 4 months, and required to give notice to creditors and all those kind of things. It's a public proceeding, but basically, we can do it. For the reasons we talked about earlier, we don't have to do it, let's not. Well, okay, so if you've done planning, and you've taken the time initially to really address the issues, and then over time you've revisited it, updated, and maybe you've taken into account something that other people that your beneficiaries say. So maybe initially you left property to daughter and son, or to brother and sister, and later on you mentioned that to them and they said, well, for whatever reason that didn't make sense. Maybe you've changed your planning. Great. But if you have planning in place, you've maximized the chance that what you want to have happen is going to happen. That's worth quite a bit. Because I'm here to tell you what a lot of people think is going to happen when they pass away doesn't happen. And they're gone, okay, they don't know about it, but it causes a lot of problems for their family. And it's so frustrating to the family. You know, they've talked to Dad, they know what Dad wanted, this direction, but they can't get there, it goes this direction. That is really, that's a bad result. With good planning, you're going to avoid that. You're going to have smooth sailing. Well, that's what I wanted to talk about this morning. Sharon, you said you had a question.
I did. If you go back to, you were talking about funding, and you were discussing if a person has a piece of real estate that is not currently in the trust, i.e. a house and some land, how does one go about putting that piece of property into the trust? In other words, what's the process? And then you also mentioned one time about dividing that in between the husband and wife, that each owns half of that. So I guess I don't understand how that works as far as the legalities of taking it down to the courthouse and saying, my husband owns this half and I own this half.
Yep, okay, well, so first of all, you're in our Peace of Mind Protector program, so you've already paid to have us help you do that.
Okay,
So what we need to do is we need to know what is that property? And if you've got the deed that came to you, that's the golden way, because then we know exactly how your name is titled, we've got the legal description. If you don't have it, fine, we'll get it from the clerk and recorder. We want to get the old deed, and then Tanya, sitting right over there, she's going to do a draft of the deed for me to look at from Sharon to Sharon's trust. Okay, now is it going to go to Sharon's trust or is it going to go to Sharon and Rob's trust? That's to be decided, and there's no legal rule saying what it needs to be. Part of our work when we've done our trust, we've got it all set up, and we're saying, okay, now what assets need to go where? If it's a couple, we're going to, generally, I'm going to say, you know, it doesn't have to be totally equal, but what about if we kind of had the estates, the two halves, more or less equal? If we have an estate tax liability, that's a good thing. If we don't have an estate tax liability, it's not so important, but I still think it makes sense. So we'd look and see, well, what's already on Sharon's side of the ledger, what's already on Rob's, and if Rob's real heavy because he's got a big retirement plan or something, maybe Sharon ought to own that house. Well, I find a lot of people saying, it's our family house. Can't we both own the house? Well, yes, we can. We could have it owned half by Sharon's trust, half by Rob's trust. In that case, the draft of deed that Tanya's going to do, it's just going to say the house goes from, maybe it's now Rob and Sharon, to Rob's trust, to Sharon's trust. Now, when it does that, it's not joint tenancy with right of survivorship, like it can be for a couple where it automatically goes to the other owner. It's what's called tenancy in common. Meaning, if we did that, if we took your house and we said it's owned half by Sharon's trust and half by Rob's, and Sharon gets hit by the bus, then we need to look and see what does Sharon's trust say about her assets? Where do they go? In other words, that house doesn't automatically go to Rob's trust unless Sharon's trust says that,
okay,
which it probably does, but we'd look at Sharon's trust.
okay,
Does that make sense?
yes.
What about a disability like Alzheimer's? And I end up going to Missouri, you know, and with full-blown Alzheimer's. I still have to pay my own freight out of the trust, right?
Yeah, so, and I didn't do a good job. I said I was going to restate the question, but I didn't do that for Sharon, but I'll restate it for you, Randy. So, question is, what if I get Alzheimer's? Do I still have to pay the bill out of my living trust? And the answer is yes. So, you get Alzheimer's, comes on immediately. Tomorrow, you need to go up there to Grandview, and if you need the highest level of care, it's only $9,000 a month. So, you need to start paying that. And then if somewhere down the road your wife says, I wonder if we have some alternatives. And she's talking to me, I'm going to say, well, Randy has a living trust, as you know. That's not going to affect what we can do. It makes no difference whether Randy has a living trust or he just owns it in his individual name. He qualifies for benefits or he doesn't qualify based on Randy's income, his expenses, and his assets, whether in trust or not. So if you're paying $9,000 a month and you're wanting to do something about that, to get some help, you're going to have to do what I called long-term care planning earlier on. You're going to have to change the ownership of your assets. Part of it could be changing what are countable assets to non-countable. For instance, a house where your wife's living is not countable. So maybe you're living in a very modest little house and you say, geez, I'd like to at least save part of this. Okay, darn it, we got to buy a nicer house. That's totally allowable, and that house will not be a countable asset. Or we're driving a 52 Studebaker, and it's a real classic, but muffler keeps hitting the ground. We can buy a car. That's not a countable asset if it's being used by the family. Those kind of things. So we have the ability to change assets from countable to not countable. Also, we can purchase, there's a certain kind of an annuity that we can purchase that will allow us to protect part of the estate. But the living trust-based planning we've done doesn't help us. Doesn't hurt us, but doesn't help us. Does that make sense?
Yeah.
Does long-term, like nursing home coverage or insurance, does that come into your long-range planning, long-term care, like insurance for?
Yeah, so the question is, what about long-term care insurance? How does that come into this? Well, when I do have people come in who are, to me, want to talk about long-term care expenses, the first thing out of my mouth is, do you have any long-term care insurance? If not, should we spend a minute talking about it? I've got some, by the way. Becky and I bought some a while back. I think it's really worth looking at. The problem with long-term care insurance is, first of all, you have to be insurable. If you waited too long, if you got Alzheimer's, you're not buying it for yourself.
Yeah.
Plus, the older you get, the more expensive the premium gets. You know, when you buy a life insurance policy, that premium stays level the whole policy term. With long-term care insurance, no. This year, it's only $5,000 a year, but when you're 85, they might have bumped it up to $20,000 a year or something. So that's an issue. Long-term care insurance, there's really two kinds. There's the straight insurance, where you buy a policy and they say, you pay your premium, and if you cannot perform two of the, they call them activities of daily living, if you can't perform two of those, we'll start paying you up to $200 a day for your period of disability. That's the one kind of. The other kind of long-term care, it's a rider on a life insurance policy. So you bought $1 million life insurance policy, and you've got a rider that says, if during my lifetime I can't perform two of the activities of daily living, then the life insurance company will start paying me for the nursing home or for the aid at home or whatever, and it'll be subtracted from the death benefit that's payable to my estate when I pass away. A lot of people like that better because with the first kind they think, well, if I never use that, money's wasted. Well, I don't think it really has been, but I get that idea. So those are the two kinds, and to me they're really worth looking at. The problem I find is usually the people I'm talking to, it's not going to work for them.
I have a couple questions.
Sure.
First of all, a house that's held jointly, can you put a beneficiary deed on to name successors?
Okay, so the first question is, if we have a house held in joint tenancy, could we put the beneficiary deed provision in place so it go to a third person when both those people are gone? The answer is yes.
And you do that at the courthouse, or?
Well, I don't think you can do it. Someone's got to prepare that deed.
Okay.
Honestly, we've done very few beneficiary deeds in our office. We've done a couple of them. But most of our clients are doing more advanced planning. But somebody could help you do that. Might even be able to download that form on the internet, possibly. I don't know.
Okay, my second question, these people probably know, but when you establish a living trust, any of the assets you hold now have to be reestablished with a cost basis at that time, so you might be subjected to a lot of capital gains taxes?
Yeah, that's a super good question. So the question is, if I set up a living trust and I transfer my assets into the trust, is that going to require the basis of the assets be stepped up to the value? In other words, is that a taxable transaction, a taxable assignment? Because it's a revocable living trust, it's ignored for income tax purposes. It's what Uncle Sam calls a grantor trust. So you transfer, I don't care what you put in there, whatever it is, your basis is the same as it was before. You haven't helped the income tax basis, but you haven't hurt it. And you don't report that transaction. So we set up our living trust today, and next year when we do our income tax return, you can't even tell from the income tax return we did the living trust. It has no effect, and it doesn't change our basis. It's still whatever your basis was before you set up the trust.
And when I die, is it stepped up then?
When you die, what's in your living trust is treated as if you still own it, gets to be stepped up.
Unless it goes to the bypass trust, where,
Well, it's going to be, so I breezed through that. But the basic proposition is, when somebody passes away, we need to figure out what property that they owned, and if it's in their estate, meaning it either belonged to them or belonged to their living trust, it's gonna get a step up in basis. Whether we have a bypass trust or not, it'll be stepped up. What I was saying, then, there's a difference on how we leave it to our spouse. Does it get a second step up when the spouse passes away, or are we stuck with the basis when poor old dad died 20 years ago? Any other questions?
Just one more. We
Sure.
probably have it in our notes when we had our meeting with John, but what would be the annual cost for somebody to administer the trust if the one you designated decided it was causing too many problems?
Yeah, well, there's no law that pertains to that. For instance, if a person has a will and a personal representative is named and serving, Montana law has what's called the maximum fee, the statutory maximum fee. We don't have that for trusts. So what your trust says, that John drafted, it says my trustees are entitled to reasonable compensation, and it's not specified. So if it's a family member, they might not charge anything. If it's a CPA, they're probably going to charge at their hourly rate. If it happened to be a lawyer, I don't recommend that, but if it happened to be a lawyer, they'll probably charge at their hourly rate. If it's a trust company like Davidson Trust or US Bank Trust, they have an annual fee that they charge, and while it's negotiable, it's generally based on the value of the assets. So it might be 1% of asset value or something like that.
Is that a nominal charge? Is that fairly close to what they actually charge? I've never checked that out.
So the question is, the value I just talked about for a trust company, about 1%, is that in the realm? And that is. Yeah. Now, a trust company, they're not regulated. They can sell their service at whatever level they want to. I have the feeling, without having really checked, it's pretty uniform. They all know what everybody's charging. And for instance, I like trust companies, but for a smaller estate, they're going to have a minimum fee that's probably going to seem disproportionate. But as you start getting a larger estate, you might pay a little bit more, but you get what you're paying for. For instance, I've got a matter right now involving a trust where a lady from Power died in 2006, and she named her two or three boys as trustee. I can't remember. Anyway, one of the local boy, he was supposed to be in charge. The other boy in California was not involved. The local boy was an alcoholic, and the boy in California wasn't involved. So the local alcoholic's son died, and the California boy stepped in, and nothing had been done really according to Hoyle for X number of years. And then the California boy thought, since he's trustee, he'll just start doing everything himself, and he was just totally out of control. So it wasn't that large of a estate, but I said, we need a Davidson Trust kind of a entity to come in here, at least for a while, and get control of this thing. And maybe it's too expensive in the long run, but have them come in. They know what returns need to be filed. They know how to get things set up. They know how to conservatively manage things. And then maybe once it's on a business-like basis, maybe we can turn it over to a local CPA or somebody else. But that, to me, is the kind of a circumstance where an institutional trustee can really be useful.
What or how do you, this case you just cited, how do you have the authority as executor, or how do you have the authority, or who has the authority to say, here, this California son's out of control, this needs to go to Davidson Trust, shall we say, when the two sons were the ones that were set up?
Yeah. Well, this does not involve a living trust. This involved a lady who died with a will. Okay. So the court has ultimate authority. In this case, we represent one of the beneficiaries, one of the kids who was not a trustee. And such a big mess. I talked to the other lawyers involved, and I said, normally I wouldn't recommend Davidson Trust because it's going to be too expensive for a little thing like this, but what if we think about that? So I made the recommendation, the other people agreed, and we finally got the California brother to back off, not object. We had the court appoint Davidson Trust as the trustee. we went to them and said, Judge, we've got this trust, it's run amok since 2006. Davidson Trust is not named, but we've agreed to name them. Would you officially name them? That make sense? Yeah. Jim?
Keith, on the long-term care issue, is there any particular age that it makes sense for, say, one of my children to be considering that, depending upon what kind of assets they own and whether they don't need it? But otherwise, is it 50 years old, or is it?
Yeah. So the question is, how does age figure into the calculation when we're thinking about long-term care planning? You know, I don't really see age as being a real specific defining factor. I mean, certainly it plays into it, but when people come in, well, as I said, practically everyone who comes in our door who fills out the organizer, they always put a check on the highest level of concern for long-term care expenses. So I want to talk about it, and usually by the end of the conversation they've decided, well, I am concerned, but either I've got enough long-term care insurance or my estate's large enough to be able to deal with it. I'm not going to do anything, at least now. Other people say, no, I think it's appropriate. I tell, my rule of thumb is for people who have an estate from $300,000 up to $2 million, at least that factor to me, if they're otherwise interested, maybe they ought to explore it. But I think my job is to say, here's some options, and you've got some real options. But remember back, I started with the proposition, control is central to what we do. And when we get older, we start losing control, and my job is to keep you in control. Well, long-term care planning, you're giving up control. You're saying it's more important to me to have the family farm at Fairfield or the house or whatever go to my kids than it is to maintain control over that asset. And I'm good with making an irrevocable transfer to maybe a trust or to my kids. And because it's irrevocable, I'm going to say, you know, let's sleep on that. We're not going to do anything in the near future. And then let's talk to the kids and make sure everybody's on the same wavelength and it seems to make sense. So it's not going to be for most people. But if you're going to do that kind of planning, here's where age particularly comes in. If you do long-term care planning, you either set up an irrevocable trust or maybe transfer kids or something, and then you want to apply for benefits because you end up in a nursing home, for instance. There's what's called a look-back period of 5 years. And if you've made transfers into a trust within 5 years or your kids, you don't want to be applying for benefits within 5 years. So if you're 90 years old and your health is really bad, I don't know that you're a real great candidate for making a lot of transfers. So age comes into it that way because of that 5-year look-back period.
In my situation, I have assets, you know, real estate that we're going to put in the irrevocable. And, you know, the 5-year window, that type of thing. And I'm relatively young, and let's just say it's 10, 12, 15 years down the road, and I've done okay. And I can see that I'm certainly going to outlive my assets. And that at that point in time, I want to put more stuff, more assets into an irrevocable. And I know I was told by you guys that, you know, once you can't add to a trust because then the date starts over. So if I wanted to put more money, you know, protected from the nursing home, and I'm throwing the dice that I'm going to make it, you know, 60 months before something happens to me, do you, set up a separate? You'd set up another irrevocable trust to do that? Is that how something like that would work?
Yeah. So the question is, if a person has set up, so if a person has done long-term care planning, and that planning involves setting up an irrevocable trust and transferring some assets into it, then later on, that person wants to contribute more assets, what do? And the first rule is, we don't put the assets into the irrevocable trust we already set up, because that would start the 5-year look-back period, starting all over again for everything in the trust, even the stuff we gave away 15 years ago. So if we wanted to do more planning, we wouldn't have to use a trust. We could just give property to our kids or whoever. But for the reasons that you all know well about, and that we could talk about more if we wanted to, a trust is a really good way to handle that. To me, we would get the old trust we did 10 years ago and look at some changes to that, a similar format, and probably do a trust very similar to that for some new assets. Any more questions? Well, I hope this has been useful to you. And let me just make a little comment here. Oh, first of all, I always forget this. Tanya didn't remind me. We have this evaluation form. Would you please fill that out? And most importantly, I'd like to know, what's of interest. What else would you want us, what would you like to learn about in future sessions? Because I'd be happy to consider that. That's number one. Number two, if you're in our Peace of Mind Protector, as almost all of you are, it's an annual membership. As we get to the end of that year, I want to sit down with you and I want to talk about your planning. You may have some changes already in mind. You know, you don't want to name your brother anymore as trustee or whatever. But I have 2 specific changes to your trust, and unless you've done your trust in the last year, I want to put in there. One of them has to do with a tax provision, and the other one has to do with how we pick a trust protector, which is a topic that maybe most of you have totally forgotten about, but there's some planning in your trust to allow us to make some changes down the road without going to the court as far as tax provisions. And I want to tweak that to make it a little bit easier. So you've already paid to be members of our Peace of Mind Protector program. I want you to take advantage of it. So when Tanya gets hold of you to arrange a meeting, don't just think, oh, I don't have any changes. I've got some changes. And I've already paid for them, so let's make them. With that, thank you for coming.